that transpired. The lady up front, as your ladyship is aware, this remains an urgent application. That the circumstances under which we bring these interlocutories has in fact been caused by them, not us, my lady. And your ladyship is entitled, in the circumstances of an urgent application, my lady, in accordance with your discretion, to make appropriate findings and an order at the end. There are the following applications, my lady, that are before you. The first application that came before your ladyship was the one by Satra some weeks back, where they sought to file a supplementary affidavit. Now, that application, my lady, that too could have been moved before another court, as they will submit in respect of these applications, possibly, and certainly the amicus application, apropos what we've discussed in chambers, my lady. But the fact of the matter is they sought to move it at the hearing. You will recall from reading the papers that we took the view that, yes, the information they put up, the evidence they put up is relevant, but it's not the only relevant information. And that related to the Section 15 registration. In a few moments, I will just take your ladyship chronologically through the events that lead to that, my lady. But, my lady, for the sake of the interlocutories before your ladyship and legal submissions in regard to the timing and your ladyship's first duty to consider what to do with this matter procedurally, my lady, I'd like to start off, my lady, by referring you to a rather sage passage in a judgment of this division sitting in Johannesburg, my lady. And if I could give you the citation, it ought to be well known. It's Passenger Rail Agency of South Africa versus Swifambo, SWIFAMBO, Rail Agency, Pty Limited, 2017, South African Law Reports, 2017 6, bracket 6, my lady, South African Law Reports 223, and then in brackets, the GJ, Gauteng jurisdiction. Now, my lady, His Lordship Mr. Justice Francis in this matter is dealing with a slightly different issue. It related, in that case, to the making out of a case in reply. And that was contested as an interlocutory in the matter. What he says in paragraph 15, after he's looked at some of the legal aspects and the authorities in relation to that, my lady, bears out the following. and before I read it to you, milady, it's trite, milady, with respect that the rules are for the court and not the court for the rules. It's also trite, milady, that courts are cautioned not to be overly technical. On that score, milady, we've already said to your ladyship in chambers that the respondents have elected not to seek time to file further affidavits. I pointed out to your ladyship that they have in fact had since the 20th of April to deal with our so-called rejoinder affidavit. So they had no intention of dealing with the facts. So, milady, they want to argue this matter now on the technical aspects, and that is a matter of national importance, and there's a plethora of authority, milady, that you are aware of, milady, where how organs of state litigate has to pass muster in the constitutional context, milady. It's also tried, milady, if your ladyship, has a discretion to allow further affidavits, to amend, as your ladyship knows. Of course, we can even amend on appeal, milady. And it's trite, milady, that practical common sense must be applied. And at paragraph 15, His Lordship, Mr. Justice Francis, says the following: it is clear from the aforegoing that the court rules are there for the courts and not the courts for the rules. A common sense approach should be used when dealing with such matters. The true test is whether all the facts pertaining to the matter have been placed before the court. If there is any prejudice, that prejudice must be brought to the attention of the court. Party that is prejudiced should be allowed to file a further affidavit that deals with that. The respondent has filed a further affidavit which took care of any prejudice that the respondent may have suffered. It cannot complain later after they were afforded an opportunity to respond to any new matters. Now, lady, the respondents before your ladyship have effectively been granted that opportunity by your ladyship to say what would they like to do, what is their election. They've elected to deal with this matter not by way of facts, but to do so on the technical arguments that they advance. Now, milady, it is in our view unforeseeable that your ladyship is going to deal with our applications in a manner where you simply don't allow them to be made part of the record. And the reason for that is, milady, they go to the heart of our cause of action, and they result not on account of any fault of the applicants, but on account of the fault, more particularly, of Satra, the third respondent. We appreciate our learned friends' positions in taking their instructions and arguing this case, milady, but of course we must deal with the facts and advance the appropriate argument in relation to how the litigation is being conducted, milady. Now, milady, the amendment application, if I could just would have read in the rejoinder affidavit that the amendment application, in our view, is not entirely necessary. We say that, in fact, Prayer 2 of our current extent notice of motion is broad enough. However,
sorry, I apologize for interrupting. Can you please repeat that? Are you saying it's not necessary, the amendment?
Lady, strictly speaking, no, it's not necessary. It's not entirely necessary.
Well, you must elect now whether you want to proceed with it or not proceed with it.
Well, milady, we'll proceed with it, milady, because we say, and that is why we raised it, milady, is that it brings the necessary clarity. If your ladyship what your ladyship would have seen in the notice of motion is it does not specify only section 21. It specifies, it allows for any authorization under which children's vaccination would be rolled out. Now, your ladyship is aware that we started out with the section 21 and subsequently it has been registered under section 15. You also know from the affidavit by Satra that they want to raise a mootness point. And milady, all of these things feed into it. And I'm not going to argue the mootness point because that's not before your ladyship at present. What I'm going to argue before your ladyship is the amendment, the need for the amendment and why we brought it. If your ladyship refuses the amendment, milady, we don't believe that that negates our case at all. But we felt it was appropriate and necessary to reflect on the need for complete clarity, because once should your ladyship uphold the relief prayed by the applicants, then there would be too much scope. And remember, my lady, it's an interim order. It would not be appealable. But in our experience, what does transpire in these matters thereafter is then an interpretation and a dispute around what all that order in fact covers. And in the context of all the facts we submit, your ladyship, it is very apparent that it can and does cover the latest Section 15 decision and the appeals that have been lodged under Section 24A, the statutory appeals, my lady, including what we subsequently learned about, namely the appeal lodged by Mr. Bob Glenister. Now, my lady, you would have read in the papers, in the objections, that there is a contention that the amendment expands the cause of action. And in fact, it is said that that amendment now includes all adults. My lady, that is, with respect, incorrect. That's not at all what it reads, and it's not at all what the cause of action is sought to be expanded to. But under the Section 15 decision, the rights of children remain implicated and affected. So, my lady, it matters not whether it's under Section 21 or Section 15 that ultimately your ladyship, or how your ladyship considers the facts. They're all there. And when we argue the mootness point, my lady, which I don't want to argue now, we will tell you why the Section 21 case is not moot in any event. My lady, before advancing to this factual matrix around our application, our interlocutory application.
Can you just address me, why does the amendment not comply with Rule 28? On what basis?
So that's what I was. Thank you, my lady. You're a step ahead of me there. That's what I want to anticipate and first deal with the grounds of objection. Firstly, your lady must bear in mind, because this overshadows the first and second respondent's objection. Satra, the third respondent, has now accepted the notice and filed a proper objection. So they don't start with the Rule 30A, such as the first and second respondents do. So what you've got is you've got an objection. They've put up their grounds. That's how they elected to deal with it, and those grounds are before you. And what we did, my lady, having received this yesterday afternoon only, my lady, is we have put up an application for amendment. We've put up a short affidavit in which we point out that they've now objected, and that means we must bring our application on notice, and that we will deal with it. All of the arguments are legal in nature. That's a short affidavit that was filed this morning, and that's why that follows. That really renders the objection, the first objection, the Rule 30A objection, which I'm going to show your ladyship is in any event irregular, it renders it redundant. Now, the first and second respondents have put up a Rule 30A. Rule 30A, that's the procedure they elected, is a two-step process where they themselves must use a 10-day period first to call on a party to remove cause of complaint, alternatively thereafter to call for the relief. They go straight to step 2 in that Section 31A, I apologize, and they ask for a strikeout. My lady, it's redundant in any event, but it's irregular nonetheless. They then proceed to what they call a conditional objection. Other than
I'm sorry, I don't quite follow why you say it's redundant. I don't follow your argument.
Because Satra, one of the parties, my lady, has advanced the grounds of objection beyond the non-compliance with Rule 28 and the 10-day period. So the first and second respondents make a meal out of the 10-day period, which Mr. Rowe, based on what he said in Chambers earlier, if I recall correctly, or if it was Ms. Tilk, conceded that, yes, this can be shortened. Now, so the first and second respondents' objection...
So your contention is it can be shortened until the morning of the hearing?
Well, my lady, if you have regard to Sapra's application to file a further affidavit, they were going to move that application today. they didn't bring it in an interlocutory court. So if we had objected, well, then your Lord Ladyship would have been hearing that application first today.
Have you objected?
No, we didn't object, my lady. What we do object to, and this comes out of our affidavit, is we say you can't just come and put up the facts you want and attach the reasons you wanted to those facts. You must put up all the facts, and we're entitled to put up all the facts and to attach our reasons, and that is our rejoinder affidavit, which we submit to your ladyship, we filed as of right. Whatever the objections to it may be, you know there's a strikeout application in respect thereof. They've chosen not to file a further set of papers, a reply. They've chosen to argue a technicality, and we will deal with that when the time comes, my lady. But to come back to the point on the Rule 28 notice of intention to amend, of course we didn't set out therein we're giving you 10 days because there were not 10 days left, my lady. And so we invited their opposition. Now, they can come and make all the submissions they want to, my lady. They'd have to persuade your ladyship to exercise your discretion against us and in their favour in an urgent application where, my lady, we live under Rule 612 currently. And
well, I think Rule 6 was overtaken by the practice, the directives given by the Deputy Judge President of this division.
But lady, even if that was the case, even if that is the case, if that was an argument they proffer, His Lordship...
That's what I'm putting to you. I'm asking you, what's your argument pertaining to that?
His Lordship, the Deputy Judge President, can never foresee the outworking of a case as fluid as one like this. And it happens all the time.
I accept that. But what I'm saying is that Rule 6 has long, the horse has bolted pertaining to Rule 6 and urgency.
Well, my lady, that would just be on urgency, my lady, but under Rule 612, we see condemnation across. There could be many things under which, because under Rule 612...
condemnation.
Well, my lady, sorry, under Rule 612, you may need condemnation for forms of service. You may need condemnation for truncation of time.
I understand what Rule 6 says. I'm asking you, where are you asking for condemnation in your papers?
Lady, we say that the matter is an urgent application and the circumstances that have prevailed in this, and we say they're not of our making, are such that there was no other way for us to do than what we've done, which we've done as best possible in the circumstances to bring it to the attention of the court. And we would say that your ladyship's discretion resorts both there as well as under your ladyship's general discretion to condone matters in this court. We under the rules, my lady, the context, the factual matrix, my lady, we believe will persuade your ladyship to recognise the seriousness of the evidence we put up, the seriousness of our contention that it has been hidden from this court all along. And thirdly, it's devastating, my lady. It's never been considered by Satra. It goes to the heart of the Satra appeal, which is subsidiary to this application. We seek the interim relief pending the outcome of the Satra appeal. And we've now, we say, if I could just continue on this point, my lady, to come back to the amendment. When we launched this application, yes, that's when there was a Section 21 authorization. We stand before your ladyship today where there's subsequently been a Section 15 authorization. I've said to your ladyship, our notice of motion in Pred 2 is broad enough to cover both for the sake of our interim relief. And we've only added the amendment so as to make it absolutely clear. One of their complaints in relation to that amendment, my lady, is the reference to Mr. Bob Glenister's Section 15. We're happy to drop that out if that pleases anyone, but we have our own Section 15 24A appeal pending, which the Minister...
But how can that even be relevant? How can I make such an order on his appeal?
Well, it's because, my lady, what the cause of action is. The cause of action arises...
So are you electing to drop that or not? Are you persisting with it?
Lady, if I could just ask my attorney to take an instruction while I continue in the matter, I'll come back to your ladyship just now,
Good.
as your ladyship pleases. So, my lady, the Milady, might I say this? Even if we drop the amendment, it doesn't change much, if anything at all, in our rejoinder affidavit, as your ladyship pleases. So, milady, I've dealt with the Section 30A notice. I say it's redundant. Your ladyship sought an answer from me. I say so because Satra has engaged a direct objection, and we have now filed that amendment. And I'll come back to your ladyship on that. Milady,
I'm still struggling a bit to understand that. So you're saying because Section 28, you've now complied with Section 28, Rule 30A is not applicable. Is that your argument?
No, milady, it's not a question of whether we've complied or not, milady. It's a question that the compliance is no longer material because one of the parties has filed a proper objection. Milady, let me just allow me to, something occurs to me, and I just want to test it so that I am accurately submitting to your ladyship. If you bear with me to find.
Certainly.
Thank you, milady. Satra and Satra objection. I'm just looking for the Satra objection, milady. Somehow it is from my fingertips. Milady, I'm just going to mute myself while I just ask my attorney to give assistance.
Certainly.
Sorry, my lady, struggling with the mouse. My lady, Satra's notice objection is in terms of Rule 28.3. Now, that, my lady, is in Rule 28. That's as I recall it right now. It is the reference to where you must use the 10-day period, and let me just read it to you. 28.3 is that an objection to a proposed amendment shall clearly and concisely state the grounds on which the objection is founded. So it's subparagraph 2 that says, the notice referred to in sub-rule 1 shall state that unless written objection to the proposed amendment is delivered within 10 days of delivery of the notice, the amendment will be effected. Now, the complaint put up by the minister is that we haven't complied with Rule 2. But Satra have skipped over that complaint and have gone straight to the objection, which is 28.3, to ladyship on whether we're going to persist with the amendment. I trust I've explained that to you, ladyship.
No, but I don't understand that because then we're wasting time now. So you must make the decision surely now. Otherwise, the respondent has to react and then afterwards you say, well, I'm not proceeding with the amendment.
No. I'm just concluding on that point, and I'm going to come back to you with my instruction in a short 12 time. Your lady just asked me that you hadn't understood my submission, so I just clarified it. Thank you, milady. Milady, the other application that is before you by Satra is a strikeout application. But of course, there's no strikeout application to be argued here until your ladyship has dealt with the objection to the supplementary and the rejoinder. So I'm going to deal with those first. And the strikeout application is something we would only deal with after your ladyship makes a judgment pursuant to this morning's proceedings. So that's the other application, my lady. And that takes care of the applications by the respondents. Safe to mention that indeed the first and second respondents, essentially the Department of Health and the Minister, do raise, outside of their technical objection, they raise other objections. So we'll come back to that later. The lady, the applications I want to now make submissions on to your ladyship are the applications that we brought this morning. So primarily the application for leave to supplement. Now, that application arises, milady, on two bases. And maybe best if I read our notice of motion to supplement. We ask in prayer 1 that you grant leave.
Can you please direct me to the case lines page, please?
Indeed, sir, milady. Milady, it is at section 045, document 1. It's the first item. The cheat should be the first item, milady. Case lines 045-1, and it's the first item.
Yes.
That's it. Milady, if you have regard to paragraph 1 on page 2, we pray that leave is granted to the applicants to file the supplementary affidavit annex marked A. And then annex thereto is the actual supplementary affidavit. And then behind that, milady, is the supporting affidavit of Mr. John Taylor. So when I come to argue that, milady, I will take your ladyship more fully to those pages. The second prayer, milady, is that the applicants be granted leave to file their rejoinder affidavit as a supplementary affidavit in the event that your ladyship finds that it was necessary for the applicants to have sought leave to file that affidavit or any part thereof as a supplementary affidavit and not as a rejoinder, as they did. So, milady, we say we filed the rejoinder affidavit as of right. But in their, in particularly the strikeout application, there the third respondent, Satra, contends that no, it's nothing more than a supplementary affidavit containing irrelevant information. And milady, that is where we need to venture into that affidavit and determine whether or not relevance is, whether it's relevant or not, whether it was relevant, what's in the rejoinder was relevant to what was in the supplementary, whether we were entitled to go as far as we did. If your ladyship finds that any part of that affidavit exceeds that hidden line, that invisible line between what was as of right and what ought to have been separate in supplementary, then we ask your ladyship to find that you admit it as a supplementary affidavit. Now, at that juncture, our learned friends might have objections, but they have catered for that in the strikeout application. In other words, after you've admitted it, only then really does their strikeout application come into play, and they would get that opportunity there to deal with the rejoinder affidavit. Now, my lady, in the affidavit filed in support of the application to supplement, which I've just read from that notice there, we deal with, and your ladyship, if I could ask you to go to 45, page 39. In fact,
yes, I'm there.
Now there you have the supporting, this is the supporting affidavit for leave to supplement. The first prayer that I read to your ladyship deals with evidence we discovered last week. My learned friend, Mr. Crompton, actually the third and fourth applicants, and I happened to stumble upon that information in another matter. We were not aware of what that information was, and it's very material to this case. And I'm going to show you in a moment what we did about that and why we expected that Satra would do something about it. So if you turn over the page, my lady, to page 40, you'll see there paragraph 5, the start of the purpose of the application, which is obviously firstly to file a supplementary marked A. And we say in paragraph 5 at the top of page 41 that the applicants invited Satra to raise this new information itself with the court, and we verily expected papers to that effect to be filed before the hearing commenced. We believed it was their responsibility to place this information. In fact, it is, as a matter of law, it's their responsibility to place this information before your ladyship. And verily accept it. However, instead we received, or they being the applicants, received tactical applications on Wednesday afternoon, the 26th of April. The lady, we received these yesterday afternoon. The process was uploaded to case lines we later discovered in the morning, but these documents did not come to our knowledge because they were not served on our correspondent attorney. They may have been served on one or more of the attorneys representing the parties. But those attorneys have given instructions to the correspondent attorney, as is the practice. And, milady, those documents did not come to the attention of my attorney and subsequently not myself and the other counsel until yesterday afternoon. We then, milady, had to go to work to deal with their election as how to deal with this matter. And it's in those circumstances that only this morning could we file our various applications. Now, milady, if you turn over to page 42, we deal there with prayer 1 of the notice of motion. However, the proper context, milady, is for us first, yourself and I, if I could take you to page 44, for us to deal with prayer 2, which is the conditional prayer in the event that you find we've breached this invisible line, as I described it to your ladyship. And if I could just, and I will skip, milady, and not read unnecessarily, but if your ladyship would bear with me as I take you through this affidavit. We point out in paragraph 19 the following, milady. Paragraph 7 of its strikeout application, Satra's deponent alleges that the applicants have sought to introduce matters not canvassed in the supplementary affidavit. However, when one has regard to Satra's affidavit in support of the application to file its supplementary affidavit and the heading purpose of this application at paragraph 13, and we give the case line's reference, the Satra CEO deponent stated that the sole purpose of which, that's their supplementary, is to update this court on recent developments in respect of registration of the Pfizer vaccine. So, milady, what your ladyship knows at this juncture is that it was common cause. It is common. We can accept it's common cause on these affidavits, that the Section 15 registration is relevant. They do something else in that affidavit. They tell your ladyship in that supplementary about the second applicant, Save the Children's, further Section 24A internal appeal, statutory appeal, this time against the Section 15 registration. So, milady, in 20, the point is made, the applicants agree that the registration of the Pfizer COVID-19 vaccine is relevant, but not only for the reason Satra says, nor for the reason Satra does not say. And milady, our point in paragraph 21 is that Satra selectively put up two facts: registration and the fact that we'd appealed against it. Now, milady, they didn't say in that affidavit that they intend to raise mootness before your ladyship, and we deal with that in the rejoinder. But we knew that because of their conduct before the appeal committee, which we speak to in the rejoinder, which we say has been unlawful conduct in the extreme, in that they refuse, in their own appeal, Section 24, a statutory appeal process, to put up a full record of decision. And in the rejoinder, if your ladyship had opportunity to read that, we set out how they've done that repeatedly in the face of directions from the chairperson. And they are in breach of a plethora of authority, milady. They don't care. They are, and the latest we point out is they've said to the chairman, well, we haven't abided your direction. We haven't put up the full record of decision because we're going to argue mootness before you. He said to them, that does not relieve you of your obligation to put up the record. You will argue mootness before me with the full record. But he then said one thing further, it's all in the rejoinder affidavit. He said, if you come before me without that record, I will decide this matter without that record. And it can never be found in their favor without that record. Now, we'll get to mootness later, milady, but that doesn't fall away. But in any event, as they pointed out in their supplementary affidavit, Save the Children, Free the Nation, or was it the other, Free the Children, Save the Nation, milady, have also appealed against the Section 15 registration. Now, Satra's argument on the mootness would be, well, Section 21 falls away. We say it doesn't, another argument for another time, milady. But even if it did, the Section 15 allows for children to be administered with a vaccine, in respect of which we have raised more than the spectre of irreparable harm in the papers. Now, where this all goes to is, I'm going to show you, ladyship, that Satra did not consider a vital piece of evidence, namely vaccine injuries, because Pfizer hid that from them, either in respect of the 21 authorization, nor in respect of the Section 15. They only learned of the Pfizer injury document, the report, after they'd made both decisions. In these supplementary affidavits, we show you, with evidence, which has not been denied, but we have the evidence that the CEO, on the 15th of March, some 4 days after they had filed their supplementary affidavit, in a webinar, conceded to the world that Satra had never seen that document at the time of its decisions. Now, that is why we say, milady, it's devastating to their case. We say they can't survive beyond that, but at the very least, what your ladyship has before you is a clear case. Our prospects of success are very high, milady, and we believe we can persuade your ladyship to grant us that interim relief. Now, if I continue, milady, and maybe just take your ladyship to 25 on page 46. We're making the point, milady, that everything set out in the rejoinder is relevant because it is all directly connected to the status of the Section 24 statutory appeal, which is subsidiary to the interdict application before your ladyship. Now, I'm going to go to the rejoinder application, but in 26 we point out to your ladyship that the receipt of Satra's application and supplementary affidavit a few weeks ago came nearly 2 months after it registered under Section 15 the Pfizer COVID-19 vaccine. We had no knowledge there was an application before Satra by Pfizer. We had no knowledge that Satra intended to register it. And in fact, milady, it's on these papers clear. They didn't even tell the appeal committee through our first rounds, which occurred between the 31st of January and the 11th of February this year. They didn't tell the appeal committee until the 14th of March in a letter, if I remember the date correctly. After that supplementary, they didn't even tell them the appeal committee, that there was a registration. And on the 14th they did, and they raised the spectre of mootness. Now, milady, and one must reflect on what we tell your ladyship in the rejoinder application, which we say we filed it right, and the application for the supplementary affidavit today. You must reflect on that, or consider that, by reflecting on the matter and how it started. Lady, you would have read in the papers that we in fact say we launched this application on or about the 30th of October. We served it. The 1st of November was an election day, and the courts were closed. We could only issue and get a case number, lady, at court on the 2nd of November. This application was not launched on the 2nd of November. It was issued then, but it was served as far back as the 30th. And that obviously goes to the urgency argument, which your ladyship largely appears to not consider too relevant, but I'll leave my learned friends to make submissions on that, milady. But what one must then look at is, how did Satra conduct themselves? And I'm not going to bore your ladyship by going to the chronology, but if you follow the chronology, and you see how they delayed in filing and answering affidavit. And then if you have regard to their answering affidavit and the criticisms in our replying affidavit, that Satra's answering affidavit is substantively deficient. Now, the minister, on the other hand, and Mr. Crisp, they take a different approach. They were somewhat cooperative. They did what they ought to. We are not severely critical of them. And they put up a substantive answer. The problem is, and they rely on their expert, in particular, Mr. Karim. As I recall, there's another expert, Mr. Schwab, but we've never received a signed expert affidavit from him. We certainly don't have it in our possession. If we're wrong, we'll be corrected. But those experts, milady, cannot speak to this appeal. In fact, Mr. Karim, or Dr. Karim, is one of the appeal committee members who's given directives to Satra to file the full record of decision. It's quite apparent that even Dr. Karim had never seen this Pfizer report. He only speaks to one death that he's knowledgeable of in respect of a child. And it's quite apparent from his expert affidavit, he's never seen this report. But even if he had seen the report, milady, at this stage, it's irrelevant because we now know that Satra never saw this report. And we also know that Dr. Karim has never seen the record of decision. In fact, he and the other appeal committee members are wanting to see that record of decision in the appeal committee hearing, which Satra refused to put up. Now, when the second point of criticism that's raised against us, milady, is that we took time to file the rejoinder affidavit, and it came late. Milady, the Satra application for a supplementary affidavit was obviously purportedly brought in terms of Rule 611. But Rule 611 is a procedure that you use interlocutory to take to an interlocutory court. Now, we don't have any difficulty with what they did ultimately, milady, because we appreciate the exigencies and the urgency of this case. What they did was they said they'd move it before your ladyship on the day. Now, we didn't oppose it. They probably knew we weren't going to oppose it because they knew that was relevant. But what they ought to have anticipated is that we would put up all the other development evidence that they don't put up and don't tell your ladyship about, or particularly their conduct. Well, we don't expect them to report on their own conduct, but they must have known we were going to report on their conduct, as we do in the rejoinder, because it all goes back to what, milady, the Section 21 appeal. They also, of course, as I've told you, they raise the Pfizer registration. They tell you we've put up an appeal there too, and they must have anticipated we're going to include all of these facts. Now, what we say to your ladyship in this supplementary affidavit, supporting affidavit today that I'm reading from, milady, we tell your ladyship that if they had not put up those facts, we were going to file a supplementary affidavit. However, we needed to see whether they finally performed on the directives of the chairman of the committee and put up the full record of a decision instead of their minuscule, highly redacted record, which we've attached to the rejoinder papers. It's so small. If they had delivered that on the 30th, well, milady, many things could have happened. Firstly, we would have had to forget about all of their so-called misconduct because they would then finally have performed. So it would have meant nothing for us to come and waste this time before your ladyship. The 30th came and went. We explained in the rejoinder how we wrote to them, and we even said to them, look, maybe you've just forgotten, and it's not intentional. Well, they didn't answer us, as I recall. They wrote to the chairman and said, no, it's quite intentional. By implication, we have no intention of filing this record. And that was thereafter that the chairman said to them, mootness is not an excuse, doesn't excuse you from filing the full record of decision. Milady, we then had from the 30th, then to consider our position and see what all we had to put up. It's a substantial affidavit, my lady, 40 pages of affidavit itself, plus the up to 74 pages of annexures. In there, we put up a few things which are quite contentious. We put up this Pfizer report. The Pfizer report, my lady, as we point out in our rejoinder affidavit, is of great significance. And I just want to read the part that we set out in the rejoinder affidavit. Milady, would your ladyship like me to take you there, Milady? Possibly, or to stay in that other affidavit in the meantime? I don't want to.
No, you're welcome to just talk.
Thank you, Milady. So, now, Milady, what your ladyship must appreciate is, and the rejoinder explains this, they put up what we would call a minuscule record. Milady, we anticipate there are thousands of pages in this record of decision. We have called for, and it's all in the rejoinder affidavit, we've called for a plethora of documentation. In the latest affidavit, we put up a document that we've only put up there to be transparent, in which we identify even more evidence.
And this is relevant to the application before me in what way?
This is all relevant in the application before you, for you to understand why we say that the rejoinder affidavit is directly relevant to the supplementary affidavit put up by Satra. And it's directly relevant to the case that is before your ladyship, and why your ladyship, in our respectful submission, dare not find on this case without taking all of this evidence into account. In other words, we say they have no basis to seek a strikeout of any part of our rejoinder affidavit. However, in our pred 2, we say, if we're wrong, and if your ladyship considers, well, this part may be here and that part may be there, then we cover ourselves by saying, well, then, my lady, in the interest of justice, on the facts, then just accept the affidavit now as a supplementary affidavit.
And why would striking out of certain paragraphs not be relevant to a supplementary affidavit, only to a rejoinder affidavit? What's the difference of the heading going to make pertaining to the content of the affidavit?
Well, the rejoinder affidavit, my lady, is filed as of right. We don't need the leave of the court, unless, of course, your ladyship struck out their affidavit. I'm talking
about the right. I'm talking about the content, what you've just argued.
We filed that affidavit as of right. They don't seem to dispute that, but they complain about the content, some of the content.
Yes, that's what I'm asking you. So you say that it's easy for me to decide. If I decide it's not a rejoinder and I want to strike a lot of the affidavits, then just see it as a supplementary and don't strike. On what basis? What's your basis for that?
Your ladyship's discretion to do so. Your ladyship has a broad discretion. Very broad discretion. So it's
nothing to do with the fact that you then change it from a rejoinder to a supplementary.
Oh, no, lady. That's just a mechanism we're using to be of assistance to the court. Quite frankly, my lady, your ladyship could look at it and say, this is a rejoinder. They filed a rejoinder as of right. There's other material in it. And on the same basis that His Lordship, Mr. Francis, Justice Francis in Sufambo accepted it, you would accept it. We've just tried to be rational and reasonable and do the next best thing to avoid the technical arguments which ought not to be before your ladyship in a matter of this nature. So, my lady,
it's not a technical argument. You're introducing evidence the morning of the hearing.
My lady, that evidence, well, firstly, my lady, the rejoinder affidavit was at the 20th of April, not the morning of the hearing. So we're not introducing it now.
Yes, but you didn't ask that it be introduced.
Lady, with respect, we didn't have to. We had a right to introduce it once you admit Sapra's affidavit, which we don't oppose, but we don't oppose it on the condition of our right of reply. So if your ladyship wants to strike out our rejoinder on that basis, well, you have to strike out their supplementary affidavit. But you can't in our submission. It's all highly relevant and pertinent, not only to the decision, but to the interests of children, which is part of our cause of action in this case, my lady. And the highest standard, of course, that it bears, and of course your ladyship sits as the upper guardian. So, my lady, the rejoinder, whatever you want to call it, we're just covering the base. But today's affidavit, the supplementary where we seek to place before your ladyship three things, of which only two are important to us. The first is the letter, or let me say the first is proof that the CEO says to the world, when I took my decision to allow children to be vaccinated, both under Section 21 and Section 15, but Section 15 covers the whole population. We appeal it for the sake of children, the Section 15. She says, when I took that decision, or when in fact what she's saying is, when the Satra board, the directors on the board took that decision, she sits there without a vote as an executive on that board. It did not have this piece of information, this report by Pfizer, which Pfizer presented to the FDA in about February of 2021. And the only reason the world has this report at its fingertips, like we all do, is because of the Texas case, where an American court ordered Pfizer to start producing those documents over a period of 4 months instead of a period of 55 years that it submitted to that court. And we put that evidence up. And here's what it says. I read at paragraph 60, page 32 of 38. You're not there right now, my lady, but for the record, or for your notes, it's 038-32, paragraph 60. It says, according to the report, by 28 February 2021, Pfizer had already recorded the following vaccine injuries. There was a total of 42,086 case reports, 25,379 medically confirmed, and 16,707 non-medically confirmed, containing 158,893 reports, events. Lady in 61, we tell your ladyship, it's unclear from the report how many of those injuries occurred after one injection. There is a recommended 3-week gap between the first and second injections. The vaccine rollout started in the USA on the 14th of December 21. It is likely that most of the injuries recorded occurred only after one injection of the vaccine, which is most concerning because there is evidence that side effects are much more likely to occur after the second dose. The report further records, paragraph 62, system organ classes that contain the greatest number, more than 2% of events, in the overall data set, where general disorders and administration site conditions, and then they quote a figure, nervous system disorders, musculoskeletal and connective tissue disorders, gastrointestinal disorders, skin and subcutaneous tissue disorders, respiratory, thoracic, and mediastinal disorders, infections and infestations, injury poisoning, and procedural complications and investigations. And then we say the most important data in this report was that according to Pfizer, 1,223 deaths had occurred as a result of the vaccine, while a further 9,400 outcomes were recorded as unknown. Pfizer redacted the number of vaccines that had been administered. Now, that information was not considered by the Satra board. It was not placed before them. And on the 15th of March, I think it was, 14th of March this year, the CEO, who deposes to most of the papers for Satra, he had told the world Satra did not have that information before them. Now, my lady, in the first instance, we say they should have put that information up in their answering affidavit. They should have been frank and candid with this court. They weren't. Bear in mind, my lady, what we are under Section 24, what we are dealing with there is an appeal. Now, it is true, we are dealing with an administrative decision under Section 21. And, of course, we all understand administrative law. It's an administrative decision. But the Satra appeal is an internal remedy that must be exhausted. But an appeal is broader than a review. This appeal committee has more power. It doesn't just set aside. This committee can make a new decision, give direction for a new decision. The record of appeal belongs to the parties litigating as of right. The record of decision belongs to the party impugning the decision as of right. Our law is clear on that. Satra don't only put up the true facts in their answering affidavit. They then continue to register this product, not telling anybody, and that we don't know when that started. That could have started pretty much at the time we started our litigation. We were forced to litigate. The applicants were forced to litigate. Then on the 15th of January, they register. And as I've already told you, they don't tell the appeal committee until the 14th of March. They don't tell this court until the 11th of March, nearly 2 months later, in both instances. And we at the time were waiting the delivery of this record under direction twice of the chairman and the committee. And we had to wait until the 30th. When the 30th came and went, there were a number of days when we tried to prevail on them to give us the record. We lost nearly a week on that. And then after Milady, the rest of the time was taking properly analysing, properly placing before your ladyship what is in that rejoinder affidavit, so that this court is properly and truly in a position to understand it and adjudicate it. Now, so in the rejoinder affidavit, and Milady, I'm loath to go there and take your ladyship through that. Can I inquire, did your ladyship have the opportunity to read the rejoinder affidavit in all the circumstances, Milady?
I did.
So, Milady, then you would have read the serious criticisms levelled at Satra and how it conducted itself before the committee. Chopping and changing, your ladyship's read that. But
and Milady, what must I make of that? What must I make of that in this application? What is yours?
You don't have an explanation from them. They don't want to file an affidavit. They've had that since the 20th. They don't want to explain themselves. They only want to deal with this technically. They don't give you any facts. Your ladyship has to accept all of our facts there, Milady.
So are you saying the conduct in this matter before me is mala fide?
Milady,
what must I do with the argument?
It's mala fide, it's unconstitutional. Ladyship must draw from it the inference that before you in Satra, you have a vexatious litigant who's abusing process, who's abusing the law by failing to comply with it. It is it's an organ of state. It has constitutional obligations and duties under Section 195 of the Constitution. There's a plethora of case law that talks to what is expected of organs of state when they litigate. And what you see here, Milady, is a delinquent litigant. Everywhere, not only in your ladyship's court, before the appeal committee, and those proceedings are subsidiary to these. Those are the proceedings that we say to your ladyship, we make out a case that we're going to succeed in those proceedings. And we're saying the irreparable harm that's taking place must be stopped. We put up adequate evidence to give you pause, to then pause the rollout of vaccines for children. We don't say children must not be vaccinated. Remember what we say in our papers. Children can be vaccinated under the true use of Section 21, because that's another point on the merits. I won't go there now, where children can be vaccinated on the instruction of a doctor or the doctor's advice, proper informed consent. We're not stopping children from being vaccinated. But the rollout of just rolling out vaccines, lining children up at schools and in the rural areas and just vaccinating them without any informed consent, how can they have informed consent when these vaccination injuries have been hidden from Satra, and Satra is not telling them? In this affidavit, this latest supplementary affidavit, we show you what Satra's response was. Instead of informing people in writing, the CEO did do that in the webinar, but instead of informing...
Just a moment. Yes, I see Ms. Talk has raised her hand.
Yes, it's me, milady.
I apologize.
I apologize, milady. I really don't like jumping up, but we are traversing now so far beyond anything which has to do with an application for admission of an amendment and an application for admission of a further affidavit. And we are squarely in other proceedings and arguments which might, perhaps, be relevant if we ever get to the merits. And we are concerned about the passage of time, my lady. As your ladyship pleases.
Thank you. Your answer there too, Mr. Willis? Well, that is what I was asking you. Why are you giving me this information? How am I to use it in your submitting to me that I must use today's supplementary affidavit or the rejoinder affidavit?
Let me answer that question like this, my lady. In the rejoinder affidavit, you've got all the background that I've spoken to. In today's supplementary affidavit, we point out to your ladyship these two things. One, that we only learned last week that Satra had never had this information. That's what the CEO announced to the world. They never considered this, number one. Number two, we wrote to them on the 22nd of April, and we sent that out in this affidavit before your ladyship today. I think your ladyship is there now. If your ladyship goes, I'll just take you to where it's quoted in the affidavit, my lady. It's easier that way. Would you believe? Where's my which affidavits are sorry, my lady, I'm just looking for I can take you to the letter. Maybe I should just take you to the letter, my lady. If your ladyship goes, I need to ask your ladyship to go to section 45, and I'll talk you through these three documents, my lady.
Section 45, what page?
Page 15, my lady, thank you. Sorry, my lady, we go to 13, my lady.
Yes.
So on the 22nd of April, we wrote as follows. Attorney Wright, we refer to our client's rejoinder affidavit served and uploaded on 20 April 2022. In anticipation of any contention that the matter be postponed, we insist that a substantive application for postponement be timely served and filed. Absent a substantive application for postponement, we accept that the matter will proceed on 28 April.
So why do you write that? So why is that written?
Well, that's written.
You know, you suspect it's out of time, or what's the purpose of paragraph 2?
Lady, the purpose of paragraph 2 is to make clear to them what our position is. One, we are reasonable and rational. We invite them to just do things timelessly for our benefit, for the benefit of the case and the court. We're not being unreasonable, but we just expect and anticipate. You see, my lady, in the context of everything I've explained to you about what our position was, and Satra belatedly giving their application as their supplementary affidavit under an application to us, we knew that they're putting up this very limited set of 2 facts. We knew there's a lot more that's relevant to this, and we knew we were still waiting. Before that, we had to wait till the 30th of April. So, my lady, we had a Hobson's choice. Don't put the evidence before the court, or file the rejoinder in the form that we filed it, at the time that we filed it. Well, my lady, that's a Hobson's choice for you. You do the right thing, and we did the right thing here. In other words, there was no scope to try and avoid criticism on the basis that they criticize us today. We're dealing here with the interests of children. not counsel and legal representatives' interests, milady, with respect. So in paragraph 3, milady, we say, it has just come to our client's attention. And that was that day. A friend and I, Mr. Crompton, were working on another set of papers, and we came across this and we pointed it out to our attorney and client. It has just come to our client's attention that during a webinar held on 15 March, the CEO of your client, Dr. Samete Makutlela, indicated that Satra was unaware of the Pfizer safety document that reported on vaccine injuries to 28 February 2021. This report came to light due to a Freedom of Information application in a Texas court. According to the report prepared by Pfizer, the following vaccine injuries were reported, and then I've quoted that already to you in my submissions. Paragraph 4. In the same document, it was reported that a total of 1223 vaccine-related deaths occurred. It seems as if Pfizer abjectly failed in their duty to properly report on their vaccine safety data to your client. This report has been widely reported on. Due to Pfizer's failure to disclose this data to your client, its absence from the record upon which your client decided to authorize the Pfizer COVID-19 vaccine for children, and your client's ignorance thereof, it must be concluded that your client has not properly interrogated the safety of the vaccine, particularly for children, which is the essence of our client's case and the basis for the urgent relief they seek. Paragraph 5. In light of this, we submit that this information has to be brought to the court's attention. As of March 2022, at the latest, and probably prior to your application of 11 March, your client has had knowledge of this safety data, but has chosen not to bring it to the court's attention. We submit that this information is pertinent in considering the values and principles as set out in Section 195 of the Constitution. This must be disclosed to the court immediately. We invite your client to reconsider its position urgently, but in any event, to deal timelessly with this matter in further correspondence or a further affidavit. We heard nothing, milady. But what we got, and I was incorrect in my submission earlier, I think I said yesterday, it's Tuesday. It was Tuesday afternoon. On Tuesday afternoon, we got their objections and their strikeout. And that, as I've explained to your ladyship, precipitated the things we've had to do. Lady, if you turn over the page, you'll see it, page 15. There's a media release which we subsequently found in the last few days. And on the 11th of March, and this is where the turn over to page 16, third paragraph down, Satra will host a webinar to discuss the vaccine safety and adverse events. Click here to register. And that's where the CEO made the statements that she did. But in this document, you will not find them informing people, warning people. In fact, they placate fears. And then, milady, there was one other development. We felt it necessary to put this up in the papers just to be transparent. I said to you earlier, that's at page 18. They, after our attorney's 22 April letter, on the same day, you'll see the date there, Satra's attorneys wrote to the chairperson. The letter at page 18 just says, please find enclosed here with the following for your attention. Over page 19, application for amendment, Cominati 0004 Pfizer. Nothing more is said, and if you turn over the page, there's this lengthy document. Milady, we don't know what this document is. When you read it, we can see that there's a truckload of information that we're still going to ask for out of this document, but we put it up to be full and frank with the court. We've been transparent. We don't know what it means, but that's the only step they took after our letter of the 22nd, whatever they make of it. I'd expect that had they filed further papers, they would explain this document or its relevance or not. But, milady, we invited them to communicate with us, file a further affidavit. They have not asked your ladyship to give them time to file opposing affidavits, in other words, to plead over. They want to deal with this on a technical basis. We say to your ladyship, on the standard that's applicable to these organs of state, that they are litigating, they're not. Satra is litigating vexatiously, and by the minister participating in it is not helping his cause. Now, milady, ultimately, the minister cannot defend this application. He's an important part for the sake of Satra, makes his contribution, but Satra is the party that has to cross the finish line adequately in order for us to fail. It crosses hopelessly. We submit your ladyship. For your ladyship, there is this affidavit, the rejoinder affidavit. We say it's all relevant. Our learned friends will speak to it, and I'll deal with that in reply. If your ladyship is concerned about, because your ladyship can't throw the entire affidavit out, but if your ladyship is concerned about this or that, and you want to exercise your mind about that, and you don't want to exercise the discretion just to throw the whole lot in, well, we've catered for that. We said, well, then put it in as a supplementary. We've covered that base, my lady. And then, of course, our supplementary affidavit filed today with the new information that we got this week, or last week, but it only played out into this week, my lady. That's what I've just submitted, made submissions to your ladyship on. And we say all of it is one relevant. All of it, when your ladyship takes the factors into account as to how you consider the matter, my lady, we're not making out a case in reply. Our case is made out in our founding papers. We are updating this court with information that we've experienced vis-a-vis Satra, but with evidence that they are hiding evidence from this court, and we're showing that it goes hand in hand with our experience of them before the appeal committee. What inference do you draw from that? I've submitted to your ladyship. You have a vexatious litigant before you, a delinquent litigant that is obfuscating the rules and the principles and the standards for this nature of litigation. But lady, that brings me back to the amendment. I have an instruction before me, and that is, my lady, if I could ask you to go to the notice of application to amend at section 44.
Yes, and the page number?
Two, I apologize. Page 2, my lady, at paragraph, the new paragraph 2.
Please repeat the ref page number.
It's section 44, page 2, my lady.
Yes.
Then, my lady, my instructions, as I understand them, are that so what this represents is essentially our prayer 2 in our notice of motion. It's just been tweaked, if I could put it that way, to make something clear. And we would, in the second line, not move for the words and the Glenister section 24A appeal. So when your ladyship compares that to our notice of, in fact, my lady, allow me just to consider what I'm actually being instructed here, my lady. My lady, so there, I forgot at the outset just to make mention of something to your ladyship, forgive me. There was a bigger team in this matter. You would have noted from the practice notes that advocates Pierre Duval, SC, and Andrew Duminy were also in the team. And of course, we have worked on different things at different times. Advocate Duval asked me to tender his apologies for not having been able to alert you to the fact that he wouldn't be in the matter anymore. But when his lordship, Deputy Judge President Ledwaba, allocated dates, we had to take what we could and hope we could sort it out. And both him and Mr. Duminy had to fall out of the matter. But I just want to test, because they were responsible for this aspect, and I just want to test myself. So, my lady, what I've done is I've taken out the notice of motion for your ladyship's notes. That's at 003-2. And I just want to confirm what the difference is here. So what we've changed, my lady, and allow me to read paragraph 2, or prayer 2 of the notice of motion reads that pending the finalization of the second applicant's appeal and any legal processes pursuant thereto, including any review application and appeals against the decision of the third respondent to authorize the product. We don't say how it's authorized, whether it's one section or another, for use and or administration in children aged 12 to 17 years of age. The first and second respondents are interdicted and restrained. What we do in the amendment, ladies, we say that pending the finalization of the second applicant's 2 Section 24A appeals. Now, if the contention is made that we're expanding our cause of action, we're not, milady. Our cause of action is an interdict hinging on the rights of children, represented here by these applicants on their behalf. That's the right. We don't even say it's prima facie, it's a right, milady, actually. Given the irreparable harm we describe in all of the evidence, and where we criticize the deficiency in Satra's papers in particular to put up any evidence, hinging, of course, milady, in and around the various arguments they go together with. Can you
get back to what you want to change in paragraph 2?
Well, milady, I'm dealing with the fact that they argue that this is a change of the cause of action, and I accept that your ladyship knows where I'm going. There's no change of cause of action.
So you're not asking for any amendment in the amendment. You're going to ask for the amendment as it is.
No, milady. I've said to your ladyship in the second line that we're going to remove the words "and the Glenister Section 24A appeal." But I'm trying to point out to your ladyship that there are other slight changes in here, and I'm trying to be full and frank with your ladyship. Yes. So, milady, what we change it to is both of our appeals, our Section 21 and our Section 15. It's no change of cause of action. The cause of action is the same. And that's what we seek there, milady. And then I just want to see if there's anything else I might pursuant there too, including against the decisions of the third. It looks like it's the same for the rest, milady. And if there was anything there that wasn't necessary, we would gladly surrender that too. What we want to reflect in our amendment, milady, is that it must be clear that our cause of action achieves its objective, which is to stop the rollout of vaccination to children on the whole. If parents take their children and they get a script from the doctor and it's done, of course, that we don't have a problem with that. We don't impugn the 20 Section 21 authorization to that extent. We impugn this bolus rollout. It's all safe, all come and have a vaccine when there's no informed consent to make a decision as to whether one should or shouldn't take it, especially in relation to children who from the age, I think it's Section 25 of the 28 of the Children's Act, can opt for this without their parents' consent. So, milady, there's no change in the cause of action. We take out the words "and the Glenister Section 24A appeal," but we submit that the inclusion of both of our Section 24A appeals, all it does is that it makes clear what our cause of action is and how the facts have developed, milady, and an order that your ladyship would grant if you were with the applicants would be clear and unequivocal and useful in the public domain, milady, and not give rise to further unnecessary litigation. So, milady, on the context within which you received our applications and the respondents received our applications this morning, my explanation on how the Rejoinder affidavit came about and its importance and relevance, and why we say, milady, that these applications are important, because what they do is place before your ladyship evidence from which your ladyship can conclude that the respondents cannot succeed against the case put up by the applicants. Milady, I'm not going to deal with cost. We've asked in these applications costs if opposed. I don't know where it's going to go. I'll hear the submissions of my learned friends. It may be that these costs belong properly in the cause ultimately, milady. But I'll hear what they say and deal with that in reply. We thank you, ladyship, for your patience.
Thank you, Mr. Wallace. Mr. Rowe? Mr. Crompton? Yes.
Yes, my lady. I just want to confirm that the third and fourth applicants, we associate with the various relief that the first and second applicants seek in the interlocutory matters. We also associate ourselves with the submissions, comprehensive submissions made by Mr. Willis. There's just one very brief point I wish to make to your ladyship, and it goes to the relevance of the conduct of Satra and their failure to file a record in those appeals. My lady, this case is subsidiary to the appeal. In other words, your ladyship has to make a decision whether there's reasonable prospects, specifically the second applicant, in the appeal. I would submit that the information we've put before you through the rejoinder and supplementary affidavit go to the very heart of the prospects of success. They are highly relevant to the eventual decision that your ladyship should make. I think that the conduct of Satra, and especially the affidavit that was filed this morning, go to the very heart of the prospects of success. And we seek from your ladyship the inference that we have reasonable prospects of success.
Thank you very much, Mr. Granton. Mr. Royal?
My lady, I would submit this is a case where allegations of vexatiousness, which are entirely specious, demonstrate to be charitable, my lady, the misguided approach. But I would, if I were not being charitable, I would say to bring allegations of vexatiousness in regard to a valid objection as to process. We don't even need the word valid objection, a reasonable objection as to process, and to seek to then go into the merits of the matter, to accuse all three of the respondents. And it's in respect of the first and second respondents, because we are said to have aligned ourselves with this vexatious strategy. Milady, when the respondents, all the first and second respondents are doing, I don't speak for the third respondents, is executing their executive responsibility, is with respect, milady, to go from arguing a matter dispassionately to arguing a matter passionately. And I approach. The first flaw is this, milady. A party who seeks the admission of a further affidavit seeks an indulgence from the court. The usual rule is 3 sets of affidavits. This is trite. There's the fourth affidavit in this matter, which a formal application for admission was made, to which there was no objection. My lady, strictly speaking, because it is hard to disentangle whether an affidavit is purely in response to a further affidavit, whether it is adding something new, clarity should have been sought by the applicants before they sought to file a 58-page or however many pages rejoinder. Because essentially all supplementary affidavit of Satra does is to say this: your application, which is replete with Section 21, has now been rendered moot because there is now a Section 15 approval. That's all it says. From that single fact, we're now in the Texas court. We're now in really very fiery allegations being directed at Pfizer. We are talking about an appeal record, a non-disclosure of the appeal record, and one just gets into this question: what does all this have to do with the matter? So that's the first misconception, that they could simply file this very lengthy rejoinder affidavit as of right. If they were entitled to file this very lengthy rejoinder affidavit as of right, I'm confused with respect. Why do we have an application for the admission of a supplementary affidavit, which basically refers back to the rejoinder affidavit? So that's the question as to the affidavit. The second point to make is this casting of false straw men as to our position. But lady, counsel for the applicant says that we made an election not to file an affidavit or not to oppose the application for admission on the merits. Lady, we made no such election. We say that before we even get to the question of whether we are required to formally get into the procedure of opposing, one has to look at the form of what was before you. Third, and it comes from the election point, casting of a false argument in which I am purported to have said that our objection has got something to do with the fact that we weren't afforded 10 days as per the rule. I said nothing of the sort. Far from it, my lady. What I said is that we should have been given a reasonable opportunity in the notice to be able to object if we so desired. And I said further that if one looks to what happens after we in fact object, despite not being invited to do so, one can see the reason for it. Because we get an application after our objection for the admission of an affidavit, for the admission of an amendment, without giving us an opportunity to say anything about it. So not only is the notice of intention to amend give us no opportunity to object, the process which follows upon it gives no facility to the first and second respondents to say why we seek to object to the amendment, which is not just a question of pure law, because if it were a question of pure law, I'm at a loss as to why we have, for the last 2 hours, heard such impassioned argument. But it essentially revolves around this, my lady. One is, my learned friend can talk about there's actually no amendment because it's always there. But one doesn't just look at the notice of motion. One looks at the affidavit. The affidavit, the notice of motion is just, in fact, the prayers which are asked for. The affidavit constitutes the pleadings on the facts in support of the pleadings. The facts in support of those pleadings are the following. We, the applicants, particularly object to this process because this is an experimental drug, in respect of which there is only at most a Section 21 authorization which we are seeking to impugn. But the drug is at an experimental stage, and you, the first and second respondents, cannot roll it out under those circumstances. Now, the application becomes not anything to do with the experimental nature of the drug. The application is that, yes, this may be a licensed, approved product under the Medicines Control Act, but the decision now, which is not anything to deal with an interim stage of approval, which is a final approval, a licensed drug, is flawed. Now, that is a new case, my lady, and we would have sought to have demonstrated that had we been given the opportunity to answer. Fourth point, my lady, is the letter, which my learned friend has quoted from, is with respect quite topsy-turvy as to the facts. It's not for an applicant for a further affidavit to then come along and say to the other parties that if you should seek a postponement, you better tell us now, failing which our affidavit must be taken as accepted. We're not going to apply for a postponement. But lady, I thought it was trite. Party seeking an amendment or the admission of a further affidavit is seeking an indulgence from the court. We have the opposite. We are told that if we resist an amendment or an application, we are seeking an indulgence from the court. In fact, it's completely backwards. We have made no election, as alleged by my learned friend. We have simply said the procedure which you have adopted is with respect flawed, because it doesn't build in any opportunity other than to hear the sound of one hand clapping.
Thank you very much.
Yes. And then the final, just as my learned junior points out, The final point is I'm left with some confusion as to why our objection is redundant, because our objection as to procedure, our Rule 30 objection, is redundant because Satra has filed a substantive unconditional notice of objection under Rule 28.3. I just don't understand it. We said
as you could hear from my questions to Mr. Willis, I also don't understand it, and I still don't understand it.
So
but perhaps in reply, you can try and address it again.
Yes, I'll be brief for 1 more minute, my lady. Our position is the following, just so there is clarity. We say we're not even at the arguing of an amendment stage. It is the applicant which would be required to make an election, which it has not done. If it seeks to amend, and if it seeks to introduce a further affidavit on the very eve of, or the very morning of the hearing, it is seeking an indulgence, and it must apply for a postponement. So if your ladyship is not inclined, and I have hesitated even getting there, because really, my lady, we are faced with the COVID vaccine, and this lawfare is unseemly. The department needs finality on the matters and not to linger it. But if your ladyship would not be inclined to simply say that neither the supplementary affidavit nor the amendment before this court, and if your ladyship would be inclined to allow the matter to linger, if there is any postponement of the matter, it would be for the purposes of the applicants bringing a substantive interlocutory application. And in the circumstances of this sort of postponement, my lady, we would say that we are so far outside of the realms of biowatch, with allegations of invective allegations of vexatiousness, which traverse the merits in a very unilateral, one-sided fashion, to justify the inclusion of documents where the reasonable approach would have been to say we seek the admission of affidavits and amendments which contain arguably new material, arguably a new cause of action. They don't have to concede either of those points. And in the circumstances, we ask that the matter be postponed. But they don't say any of that. Were the matter to be postponed, we would suggest not only should the applicants be required to pay costs, but they should do so on a punitive scale, including, in the instance of the minister, including the costs of 3 counsel. As your ladyship pleases.
Thank you very much.
As the court pleases, my lady. My lady, if I may begin with the allegations of vexatiousness and delinquency that have been leveled against Satra. It's not the first time that the applicants have done it, my lady. It's conduct which they seem prone to. At this stage, all that remains for us to say is that these allegations are unfounded, they are spurious, but more importantly, my lady, they are designed to mask serious inadequacies in the applicant's case, nothing more than that. And regrettably, they're designed to mask mismanagement in the applicant's litigation. And I will demonstrate to your lady where that mismanagement lies. Lady, your ladyship correctly pointed out to my learned friend that when they brought this application, they brought it under Rule 612. But what that application did, what approaching this court under 612 did, is it triggered in 2 case management meetings before the DJP. And in both of these meetings, the first being in December 2021, and the second being in February of this year, my lady, a structured timetable was laid out for the parties. Now, all of us involved understood, my lady, that what that structured timetable required is it required compliance from every single one of us. And to the extent that any one of us were going to step outside of that structured timetable, we needed to get the leave of the court to do so, either in advance or afterwards through a condonation application. It's as simple as that. And that's a trite principle. So your ladyship, with great respect, was 100% correct when you put to my learned friend that 612 doesn't entitle my learned friend to do as he pleases for as long as this litigation subsists. What it did is it entitled him to get that initial meeting with the DJP to place this matter on the roll as a special allocation. But once the DJP had laid down that structured timetable, my learned friend, like the rest of us, was obliged to comply. Now, there was a disruption, and we accept that, my lady, of that structured timetable. And I'm going to take your ladyship to exactly where that disruption happens. And this disruption comes about on the 11th of March, my lady. It comes about when Satra brings a formal application for leave to introduce its supplementary affidavit. I'm going to ask your ladyship to open up 035-6.
I'm there, thank you.
Now, what this is, my lady, is this is the, at 0536 or at 35.1, that's where your ladyship sees the notice of motion, which has got Annexure A to it. And at 35.6, your ladyship will see Annexure A, which is the supplementary affidavit which Satra seeks to introduce. Context, my lady, at this stage, there is a structured timetable in play. The parties have already filed heads of argument. So Satra is well aware of this. And what it does is it seeks to introduce two incontrovertible facts. And we describe them as incontrovertible facts in the application, my lady, because quite simply that's what they are. We're aware at this stage that affidavits have been filed, heads have been filed. Our scope for introducing new evidence is very limited. And what we do is we introduce the two new facts set out in paragraph 4 and in paragraph 5. In paragraph 4, the first new fact is that on the 22nd of January, a decision was taken to register the vaccine under Section 15. None of the parties can dispute the absolute vital nature of this fact, my lady. This matter could not have been heard without this fact being placed before the court. More importantly, the parties were aware of this fact. It just hadn't found its way into the papers. And so we cured that through this affidavit. The second important point, also incontrovertible, my lady, is that on the 24th of February, the second applicant had applied to appeal against the Section 15 decision. Two very simple, incontrovertible, objective facts. And that's all Satra did.
Oh, and common cause facts.
And common cause facts, my lady. Nobody could dispute these facts because everyone was aware about them. What the applicants do, and your ladyship will see that this tells us that by the 24th of February already, the applicants were aware of the Section 15 decision. They were aware that this application before your ladyship was solely limited to the Section 21 decision. They knew that. And I can take your ladyship through all of the papers filed. Your ladyship will not see a single mention of a Section 15 a Section 15 decision before this affidavit was filed. So in other words, until the 11th of March, it had not featured anywhere in none of the affidavits, in none of the heads of argument. Despite the fact that the applicants themselves, being dominus litis in this matter, were aware that something fundamental had happened, which in effect rendered or replaced the Section 21 decision. Because your ladyship will know the Section 21 decision relates to an emergency use decision. It's a stopgap for an unregistered medicine. Once the medicine is registered, that becomes the formal and proper decision. And once that happens, it replaces the Section 21 decision. So it's a crucial fact. The applicants were aware about it on the 24th of February. They were aware that the papers in this matter don't refer to the Section 15 decision, but they do absolutely nothing about it. So Satra comes, even though we're not dominus litis, we bring this to the court's attention on the 11th of March, my lady. Just about 2 weeks after the appeal is filed, we bring this to the court's attention through the filing of this affidavit. What that then, my lady, does is the applicants keep dead silent. They in no way respond to Sapra's affidavit. Absolute silence until the filing of that rejoinder, my lady. And if your ladyship goes to 38, your ladyship will see that the rejoinder comes in on the 20th of April, 2022. The rejoinder, my lady, comes in over a month in an urgent application, over a month after Satra files its supplementary affidavit. It comes in over 2 months after they lodge their appeal. Absolutely no explanation for why there was radio silence from the dominant litigant on this crucial fact, which they were well aware of. And then what you see happening, my lady, in this what they call a rejoinder, it's a 35-page document, affidavit, that they put up to deal with those two incontrovertible facts that I had taken your ladyship to. No explanation by them as to why the affidavit is traversing way beyond the scope of the supplementary affidavit, firstly. No application by them to the court to say new information has now come to light. We have to put new evidence before the court and asking and seeking the leave of the court to do that. Absolutely nothing. They put up, and you heard my learned friend say to you, my lady, they did it as of right. But any litigant looking at this document would know they simply had no right to do so. Even if it was a response to the supplementary affidavit, they would need to ask a leave from this court, and obviously none of us would have opposed it. But they go much further. They put up a ton of evidence and spurious allegations. We've described them as vexatious allegations designed to embarrass Satra, the regulator. They put that up without any explanation for why it's being handled in the manner that it is. So, my lady, in conducting our litigation, we're not in the business of throwing out allegations, but we say to your ladyship that the facts speak for themselves. It's very clear from what I've taken your ladyship through exactly where the fault lies in how things have transpired. The applicant then, rather than adopt a measured approach and say to the court, we're aware that our relief sought and our application is moot in light of the Section 15, but we would like to introduce the Section 15 in the current application. We want a postponement of this matter so that we can update our affidavits, we can amend our notice of motion, we can give the parties a proper opportunity to respond thereto, so that when the matter does come on the roll, the matter is properly ventilated on the papers and the parties are able to address the court on both the Section 21 and the Section 15. That's what a reasonable litigant would have done. Instead, my lady, they ambush all of us with a flurry of affidavits this morning as we're ready to appear before your ladyship. They insist that the fault lies with Satra. They throw out names. They call Satra all sorts of names, my lady. But they don't do what any normal litigant would have done and come to courts with clean hands saying, we know that there's a shortcoming on our papers. We want time to address that. Please give us the time and allow us to ensure the papers are in order. My lady, we say that and your ladyship will recall, and I'm loath to mention what happened in chambers, but we insisted that they must make an election. That election was, do you argue on the papers as they are, or do you ask for a postponement in order to bring your papers in line with where you want to be? They've chosen not to do that, my lady. And we would submit the consequences of that is the following: that your ladyship is enjoined to dismiss all their papers filed after March 2022. And the simple basis on which that is done, my lady, is the applicant's absolute disregard for the rules of court, the applicant's absolute disregard for basic principles of fairness. And my learned friend throws around the Swifambu decision, my lady. He need not even have gone to Swifambu. It's a basic principle that we're all well aware of. The rules are certainly for the court and not the court for the rules. But that doesn't mean he gets to do what he wants to do. Ultimately, the overriding principle, my lady, is the interest of justice, which must include fairness to all the litigants in the matter. And that fairness we would submit lay in the structured process which the DJP put in place. And to the extent that any of us stepped outside of that structured process, we needed to ask for leave. That's a basic principle, and your ladyship will know the absolute importance of that principle in these kinds of matters, where one is sitting with multiple parties and the opportunity for each one of them to derail the process if there aren't proper rules in place. So, my lady, my submission to your ladyship is the applicants have conducted themselves in a reckless manner. There's no other way to describe it, and I'm sorry to use the term. I do not do it easily, but it is nothing short of reckless. And regrettably, they must pay the consequences for their reckless conduct. And that means that everything gets dismissed, my lady. The matter must be argued on the papers as they stand. To the extent that your ladyship is inclined to give them a postponement in order to bring their papers up to speed, we would submit that that postponement cannot be on any other basis, but with full costs against them and costs on a punitive scale, simply in light of their reckless conduct. Apart from that,
there's no constitutional issues raised.
There are no constitutional issues, and BioWatch certainly does not cover this type of reckless conduct. Reckless and vexatious conduct, my lady, falls outside the BioWatch rule. So certainly the applicants would not be able to take cover under the BioWatch principle. And they were given ample opportunity to ensure that they conducted themselves in the appropriate manner. It was done all along. And certainly, like I said to your ladyship, had they just followed the rules, any of us would have been hard-pressed to stop them. But they've not done that. They've chosen this bullish approach. They've chosen to do it in a way that brings embarrassment to the other parties, rather than us all working in one direction to try and ensure that the matter is properly placed before court and properly argued before court. My lady, in relation to the objection, your ladyship and my learned friend Mr. Rome covered the principle that the objection was brought in a way that really one cannot even begin to understand how it was considered appropriate. It was an annexure to an affidavit rather than a proper notice filed. It's correct that we filed an objection. We did it in order to get to the heart of the issues before your ladyship. That doesn't in any way undermine the Rule 30A filed by the minister. The bottom line is that the objection hasn't been met. The grounds of the objection hasn't been met. So quite simply, my lady, my learned friend has not come out of the starting blocks on the objection. And there's a price to be paid for disregarding the rules, regrettably, and this is the price. So, my lady, those are our submissions. I am not going to bore your ladyship with what's happening before the appeals committee, with the real nature of the mootness issue. I think it's quite clear to everyone involved. But certainly at the appropriate moment, Satra will deal with all of the allegations that have been made that pertain to the appeal. But I don't intend to detain your ladyship with those at the moment.
Thank you very much, Councillor.
As the court pleases, my lady.
I'm assuming the amicus curiae is just watching and having coffee.
My lady, we are largely watching. I think, I'm not sure if this would be the appropriate time, but at some point, depending on the outcome of these applications, it certainly has implications for my client and cost implications for my client if there is to be any postponement. So whenever the appropriate time to deal with that issue is, we'll be ready to make submissions.
Okay, thank you. Mr. Rautenbach, are you still waiting to address me pertaining you're still waiting to hear if there's going to be a postponement of the matter. Is that correct?
Yes, my lady, that appears to be appropriate because it will cure much of the prejudice which the respondents understandably complain about. We don't want to stand in the way if that can be addressed in some fashion.
Thank you very much. Reply. Thank you, Mr. Willis.
As a ladyship pleases, my lady. I'll try and address it in the order in which it was put to you, my lady, and argued. My lady, bear in mind, with respect, this is not a Thursday morning motion court matter. This matter has been specifically allocated. We waited a long time for these dates. This contention that we were bound to a schedule of sorts by His Lordship, Mr. Justice, Deputy Judge President Ledwaba, is not correct, my lord, my lady. Simply because he regulated things up to a point, and then we were granted a date. It with respect, doesn't hold water, my lady. This matter, in fact, was initially agreed between the parties to go before 3 judges. We couldn't secure 3 judges and a date. We had to take what we got. This is a matter of significant importance, my lady. We have done everything to keep the matter on track. The big debate comes in around the rejoinder affidavit. Because if you find that the rejoinder affidavit is all relevant, and that Satra didn't put up all the relevant facts, they put up what they believed was relevant. But by putting up relevant development...
Can I just ask you this? Are you going to apply for a postponement, or are you going to fall by your argument?
Well,
stand or
lady, I don't have instructions to ask for a postponement. Your ladyship is going to find on these matters. If your ladyship's giving me an indication that you find no merit to that, then I must take that instruction.
Mr. Willis, you have filed serious supplementary and rejoinder and a notice of amendment just before the hearing and on the morning of the hearing. It's normal practice for you to then say, well, I need to give the other parties a fair hearing and a fair chance to answer to that. It was necessitated by certain documents coming to my attention, and that is why it's late, but I do accept that there must be fairness. And what I'm doing is I'm warning you that the argument on behalf of the respondents is correct. Either you ask for a postponement or you stand and fall by what you're arguing now.
Well, milady...
So I would suggest that you get instructions.
Well, milady, your ladyship has not heard me in reply firstly. I've not had that opportunity, but your lady has now told me what your view is. We don't agree that they were correct at all, milady.
Okay,
but
I'm then listening.
We don't agree, but I will take an instruction. I'm going to have to ask that the matter stand down on instructions and take that instruction. But in the meantime, milady, I want to nonetheless make the following submissions to you. I want to correct a few things. Instruction. Sorry, give me a second, milady. I just want to tell my attorney what I require him to do for me.
Certainly.
Lady, if you just give me a moment, I'm struggling to get my mouse to.
Certainly. In fact, can I ask if we can have just a 5-minute comfort break?
As your ladyship pleases. Thank you, lady.
Would you need longer, or is 5 minutes fine for you?
Lady, maybe, I don't know what telephone calls need to be made, maybe 10 minutes, and then
okay.
I can...
Well, let's say we'll be back at 1:15. Mr. You want to say something?
Yes, my lady, we would need to take instructions on this issue. Could I ask that we be given till 1:30?
Yes, that's fine by me. The matter then stands down till 1:30. Thank you.
The court pleases.
we're just waiting for a final instruction. If I could just ask for just 2 minutes. We don't need to go offline. Just 2 minutes, Valerie. Thank you.
Okay, I'll just take myself off camera. You can just give me an indication when you're ready.
Thank you, Valerie.
Thank you very much.
There's a ladyship.
I'm listening, yes.
Thank you, Milady. Thank you. Thank you for the indulgence, and thank you for the view. We would like to persuade your ladyship otherwise, but we have an instruction, Milady. The instruction is based on the fact that, Milady, this matter is of significant importance, and we have to make a decision that advances the cause of the matter. Milady, we have an instruction to seek a postponement. We would tender the costs, but we only tender them on the party-party scale, of course. If the respondents persist in wanting a punitive costs order, well, then we would submit your ladyship, or in those circumstances, to put it in reserve the costs. They can be dealt with later. And apart from that, Milady, I just wanted to make 1 or 2 submissions in relation to costs nonetheless. Before I do that, I just wanted to correct Mr. Rowan. We did not term the actions and decisions today to be vexatious. What we called vexatious was in particular the Satra conduct, which we've set out under affidavit in the papers. Today, we just say is inappropriate given the nature of this matter. Milady, in considering costs, Milady, nonetheless, this is the difficulty we had, is they've never put up what their prejudice truly is. And apart from the fact that we do the proper thing by tendering the costs, before your ladyship is inclined to exercise your discretion otherwise, notwithstanding my submission that if they want higher costs, they should then be reserved. Your ladyship has never been told actually what their prejudice actually is, and that would be a matter which would be debated at a later stage before the court finally hearing the matter once everything is then properly ripe, as no doubt your lady would like to have seen it. So, Milady, as far as the submissions on BioWatch go, Milady, this is a constitutional court matter, and my authority for that, Milady, and even the issues that arise here fall within that domain, and that is Harry Lull's case. Milady, you'll find Harry Lull in our heads. And Harry Lull makes patently clear the extent to which BioWatch does apply. This is a PUDGA application. Effectively, Harry Lull specifically says a PUDGA application is a constitutional matter. And all of these factors here, Milady, are not simply procedural because...
Excuse me, are you saying this matter is a PUDGA matter?
The entire matter is... Ultimately, Milady, this matter falls under PUDGA when... Allow me just to explain this for what it's worth, Milady. You've got an administrative action and a party's entitlement to just administer and fair administrative action. That results under, that's constitutional, Milady. This is an internal remedy that has to be exhausted first. And after that, Milady, the remedy is obviously reviewed. When we say, Milady, this is a constitutional court matter, we say that these issues all feed into them. We say that, Milady, only insofar as your lady is pressed to grant an order outside of the party order. Milady, so I repeat,
Can you please mute your microphone? Not you, Mr. Willis, please, but the person talking. Yes, thank you.
So, Milady, to repeat, we accept your ladyship's view. We accept your ladyship's, the criticisms that your ladyship has been persuaded by. We would seek a postponement of the matter because that's the only proper result in the interest of justice.
Yes, it's not a satisfactory result because obviously I had to read these papers, make them my own. And in this division, it means that I had to do that over weekends, on the holiday, and at night times. So it's for nobody is this a good situation. And I cannot foresee that we can postpone it to a specific date because the intermediaries will first have to be dealt with.
So, milady, can I say this, milady? Your ladyship has read the papers. It may be so that the applicants held onto this date too dearly given the interests at stake. And obviously, once this matter is now postponed, milady, if I'm allowed to be so presumptuous as that's what you're going to allow, then, milady, of course, we would need another date. For this matter to be passed to another judge, milady, would obviously, or to be a date to be found and a judge on the roster to be found, that might take longer than us prevailing on your ladyship to retain the matter, especially in that as much as your ladyship has done two things. You've sought to prepare on the matter and you've also sought to act in the interest of all the parties. So, milady, we would, in that, I've taken the opportunity, milady, to prevail on you to maybe retain this matter and to assist the parties ultimately in bringing this matter to finality in the nearer future rather than the longer future.
Yes, we'll discuss that. Perhaps the other parties don't particularly want me to carry on with the matter. But we can discuss that later when I've made my decision whether there will be a postponement. Yes.
Yes, milady. So, milady, the interests of justice dictate this matter. If your ladyship doesn't postpone it, well, then your ladyship obviously would need to, one, hear me in reply, decide the matter, and then decide.
I'm not taking away your right to reply, Mr. Willis.
No, I appreciate it. But your ladyship is well within your rights to express your prima facie view, and a party must do what they best consider. So, milady, I'm not. This is not. We haven't brought a substantive application. You've already heard that, and we haven't. But on the basis of your ladyship's indication, in the interest of justice, we seek that postponement to regularise the matter. We tender the wasted costs only on the party scale. And as I've said, if they want to contend for more, milady, well, then we submit that the costs should be reserved because the issues are far more contentious, as your ladyship has noticed and heard. But we are asking for that indulgence. I've advised my client it is proper to tender the wasted costs on a party. Thank you, milady.
Thank you. Pertaining to costs, can I then hear from Mr. Crompton? Yes.
My lady, I'm in a similar position as Mr. Willis. We seek a postponement. We tender wasted costs on a party basis. Those are instructions.
Thank you. Mr. Rowe?
Thank you, my lady. My lady, you've heard our submissions. We won't repeat them. We don't submit that it would be proper to say that if we persist in what we have sought as to costs, that ipso facto the matter of the costs must therefore be reserved. It's not on the basis of prejudice. My learned friend Ms. Pillay set out with respect correctly that it's really to mark the disapproval as to the reckless disregard of procedure and common reasonableness. As your ladyship pleases, you've heard our submissions as to why we would prefer the matter proceed, and I won't repeat them.
Thank you. Thank you, Ms. Pillay.
Malay, we have, like Mr. Rom, we also persist in our initial submissions. We submit to your ladyship that the conduct of the applicants cries out for a punitive cost order. So we do persist in seeking a punitive cost order.
Thank you very much, Mr. Berger.
My lady, I don't know if the tender would cover the amicus's costs as well. If it does, then we would be satisfied with that tender. If not, then the issue of costs should be dealt with in the main application.
Thank you. Mr. Willis, does that include the present admitted amicus costs?
No, my lady, it ordinarily doesn't, Mr. forget Jonathan's surname, sorry. Mr. Berger's submission is correct. That ought to be reserved. Milady, can I just respond? The allegations, the argument that punitive costs are warranted are very, very fact-based. Your ladyship ultimately is not going to make that determination. So we would submit to your ladyship that the proper order is a cost order.
But the argument is the fact that it was brought today, that from the 22nd till now, yes, they accept stuff had happened, which may have necessitated that you filed different things or whatever, but that you should have approached the court for condonation, or at least have filed an application for condonation.
Your ladyship
for allowing the court to allow a further affidavit, or for the amendment to be properly heard.
Your ladyship
it's not based on any other facts. It's not based on the facts of the matter.
Well, milady, they based on facts. Then your ladyship needs to have regard, milady, to our affidavit that put up the explanation. So I only took you through part of that, and that's today's affidavit for a supplementary affidavit. Your ladyship informed me that you had read through the rejoinder affidavit. But to make that determination, milady, you need to have specific regard in relation to the affidavit we filed today for supplement. Because therein, milady, are the full facts which explain the Hobson's choice back on the rejoinder and the Hobson's choice here in the interests of a matter, milady. If these applicants were simply to take the view that, well, let this drag on and that's just how it is, milady, it doesn't reflect the interests of the matter. And as we've always said, we appreciate they may want to reply, and hopefully they will in due course, milady, but that doesn't fall to make our conduct reckless. We would ask you to please, milady, before just making a decision here now, to then reserve your issue on costs, please have regard to our affidavit filed this morning, which we've made submissions to you on, bearing in mind, milady, that there's a far bigger factual matrix to this matter than what time has allowed us to actually submit to your ladyship. Milady, it's not deprecating behaviour. Your ladyship's got to properly contextualise the actions of the applicants. They were not malicious. They were done in order to do the best, to see whether a matter could be retained on this roll and heard.
Let's for a moment say we accept that, but I mean, you had to be nudged to ask for a postponement.
Lady, no, milady, you're right, milady. The postponement of this matter is not ideal. But we've debated the various issues arising this morning, and your ladyship has given us your prima facie view, and we've made an election. We've had to make an election on that, milady. We don't accept the submissions that it was for us to ask for a postponement of a matter of this nature. Milady, this is an urgent application. Urgent matters come before a judge, and then the judge decides what will happen. It wasn't for the DJP to decide what's going to happen today. It was for your ladyship to decide what must happen, and your ladyship's given us that indication. So, milady, this was not reckless. We're in an urgent application. I remind your ladyship of Republicaans. It's Republicaans of PAFs. It's very well used in your division as well.
Yes, exactly. In that matter, it says that the only thing that happens with an urgent matter is that the time periods are shortened, and the hearing and no time periods were given for the amendment.
Well,
there's no time for them today to answer to a supplementary affidavit.
Well, lady, we could have arrived in this court on Satra's affidavit. We could have objected to it on the basis that it doesn't put up all the facts. We may have filed our own affidavit. Things could have been very different, milady. These are fluid things, milady, and the point is that on the proper test, milady, in an urgent application, a court largely tends to accommodate an applicant in a matter of importance. That is stated many times over, milady. And we would say to your ladyship that there were prospects that this court would entertain that approach today. There was no malice. We described the conduct of another party on facts, We don't just say them out of the air, we put them in an affidavit. We're entitled to do that. But, my lady, there's no malice on the part of the applicants to derail this application. On the contrary, the applicants have done everything to keep this on track. And, you know, my lady, the bigger picture, my lady, is that if they want their punitive costs, they want it to be deprecated, well, that can happen in due course, my lady. That can happen after a fully fleshed out hearing in the matter by yourself or another judge, my lady, and then an appropriate cost order can then be made. But we've done what our clients have done, what we believe is the right thing, and tendered them on the party scale, my lady. We thank you for your ladyship's indulgence in time and listening to us. Thank you, my lady.
Thank you. I'll give my ruling at 14:30.
As your ladyship pleases. Thank you.
The court will adjourn till then.
I always had my nose in a book.
My ruling is as follows. The applicants in this matter brought an urgent application seeking an order that the Minister of the National Department of Health is interdicted from rolling out the Pfizer BioNTech COVID-19 vaccine to persons aged between 12 and 17 years, pending an internal appeal and ancillary relief of adequate publication of such order and the emergency use of an administration of the vaccine on a case-by-case basis to teenagers with comorbidities. The respondents opposed this application. Section 27 had been admitted as an amicus curiae. The organisation Help South Africa also had an appearance today from counsel, but have not been admitted as such before the court. And my order is that they must be admitted. The application must be enrolled and heard before this matter is heard. In other words, they must bring such application before this matter is finally heard. It is common cause that the third respondent sought permission to file a supplementary affidavit setting out new facts, and there was no objection to this affidavit that was filed. A rejoinder affidavit is then filed substantially later by the applicants, not limiting its answer to the incontrovertible facts, of which the most important is that on the 22nd of January, the vaccine was registered in terms of Section 15, which of course would impact in this matter. And this came to the applicant's knowledge already on the 24th of February 2022. On the 20th of April 2022, the applicants then file a rejoinder affidavit setting out new evidence. And it's strike law that if they want to file such a further set of affidavits, they need the leave of the court to do so. A further supplementary affidavit is filed this morning, once again not seeking the leave of the court for it to be made part and parcel of the papers, and consequently, because it was done so late and not timeously, the respondents have no time to consider their position or file an answer or whatever they would want to take to such further affidavit. An amendment of the notice of motion is also filed. It's common cause between the parties that it does not adhere to Rule 28.2. It simply does not afford the respondents a time frame with which they can object or whatever stance they want to take. The third respondent objects to the amendment, and the first and second respondents file a Rule 33A notice. This morning, an application for the amendment to be heard or then decided is filed. From all these common cause facts, it is clear that the matter is not ripe for hearing. I want to state that especially where this matter can be categorized, if it can be, as a matter of national importance, the audi alterum partem rule begs adherence, and not that it's negated just because it is urgent. An urgent matter of this magnitude and importance is as a rule managed by the Deputy Judge President of a division. This was in fact done. The directives that the Deputy Judge President issues must be adhered to. If new facts arise, which plausibly can happen, and requires further affidavits to be filed, then the rules kick into place, and they must be adhered to. The only deviation with an urgent matter is the abridgment of periods. In other words, if normally you were allowed 10 days, you can perhaps in the circumstances argue that 5 days, because of the urgency, would be reasonable. But not setting out any time periods is simply bad in law. I refer to the well-known matters of Republikeinse Publikasies Edensbeperk versus Afrikaans Pers Publikasies Edensbeperk 1972-1, SA 773A at 782A to G, as well as Luna Meubelvervaardigers Edensbeperk versus Makin, trading as Makin's Furniture Manufacturers 1977-4, SA 135W at 137, as well as Sikwa versus SA Mutual and Fire and General Insurance Company Limited, 1977-3, SA 438W at 440G to 441A. I want to venture by saying that, in fact, the respondents in this matter must be, I don't want to say applauded, but by not objecting to the postponement, which in fact they could do because it's not filed timelessly, the reasons for the delay is not before the court, there's no substantive application for postponement, and in fact, as I've placed on record, the applicants had to be nudged into exercising its discretion to apply for a postponement. By not objecting to the postponement, they have in fact acted in the interests of justice. The only recourse they are seeking is that the costs must be paid on a punitive scale, and the reason for that is that the court must show its displeasure with the way or the process that the applicants in this matter are following. The applicants in this matter clearly will have to change their stance in that because the matter is so important and it's urgent, it does not mean that they do not have to adhere to rules. And it seems to be their practice, because I agree with counsel for the first respondent, that sending a letter to them, setting out, well, we find a rejoinder affidavit and you must now seek a postponement, instead of saying, will you please accept this affidavit, shows either a lack of insight or a fact that because it's urgent, the matter must just proceed on the basis that all their documents must be accepted. The fact that a matter is urgent, as I've already stated, does not mean that the audi alteram partem rule does not have to be adhered to and that the rules of court disappear. It's trite that the court can deviate from court rules, but it has been stated over and over, and again in the matter of the South African Airways, SOC versus BDFM Publishers Pty Limited, where my brother Sutherland expressed strong views of the fact that procedure must be followed in urgence and that the principle of audi alteram partem is sacrosanct in the South African legal system. The question then that I have to decide is whether the costs which the applicant have offered on a party and party basis must be on a punitive basis. I've decided not to grant a punitive cost order, and the reason for this is that by offering the costs and not relying on the BioWatch principle or making an argument about it, it's not to say that they can't still do it at the application stage, but they will be hard-pressed to do so where they've offered costs in this instance. And therefore, they are at risk. If the application should be dismissed, I don't know whether it would be dismissed or granted, but that they would be held responsible to foot the bill of the respondents and possibly the admitted amicus. I accordingly make the following order. The application is postponed sine die. All the interlocutory applications that are on the papers at the moment and need to be finalized, even if they can't be categorized as interlocutory, but they mostly are to be disposed of before this matter is enrolled again. The parties may approach the Deputy Judge President for a preferential trial or preferential hearing date, and the parties may allude to the fact that I'd read the papers, and they may ask the Deputy Judge President that I preside in the matter, but this order is in no way binding on the Deputy Judge President. The costs for Section 27 is reserved. Thank you. The court will adjourn.
Pleases, my lady.
As the court pleases.
She made an order.
Pleases.
Did you say costs?
As the court pleases, my lady.
Let me just quickly get on, if I can get onto the screen.
She didn't. You are. It's fine. Put the camera on. I think you should speak before everybody goes.
Sorry, I just, if it's possible, if the registrar is still on.
I'm still on as well.
I'm concerned, sorry, my lady, I'm concerned that we have the reasons for your order, but we don't have an order stipulating that the costs of the postponement will be paid by the applicants. So in the case of the first to third respondents.
I apologize, you did right. I didn't read out the last order. You are right. I apologize. So there's reasons, but not the final order is that the applicants are to carry the costs of today of the first, second and third respondents.
Could we ask for a stipulation in respect of the first and second respondents that such costs would include the costs of three counsel, one of whom is senior counsel?
Yes, I'll add that for the sake of the taxing master. It includes the cost of three counsel, of which one counsel is senior counsel.
Thank you, my lady.
Thank you very much for drawing my attention to that. I don't know why I didn't read it. Thank you.
Thank you, my lady.
Anything else? Okay, thank you. The court will adjourn.